rescue my notes. So, legal background, as we know, data protection is currently governed by the Data Protection Act of 1998, but that's all going to change in May when the new regulations come into effect. Data Protection Act 1998 emanated from regulations about 1995, and that started discussions in the early 90s, which of course was like the Stone Age as regards data protection was concerned. Everything's moved so quickly, there was clearly a need to update the regulations. That's what the EU decided to do. And they're doing it by way of regulations so that there's a common set of regulations for each country in the EU. So it will be a one-size-fits-all from Cyprus in the east to Spain, Ireland in the west, what have you. Clearly, when we undertook our referendum on our membership of the EU, that threw into doubt whether we would be bound by the regulations. The Article 19 evocation runs to 1919, so clearly it's going to be about a year when we'd be just governed by the regulations. But the government flagged up quite early on that they were determined to be GDPR compliant, as it will help with business, in particular transfer of information across European boundaries. And so the Great Repeal Bill will bring in the GDPR into English law, and as a backup, the government have also introduced a data protection bill, which is winding its way through Parliament, and that will also bring into effect the GDPR. So UK law will be bound, and it will be should be a seamless move. Are there going to be any major changes? Well, some things are going to stay the same. All the definitions of personal data, sensitive data, you know, concerning sexual orientation, trade union membership, any health issues, that remain the same, although they've changed the name to special categories of personal data. And principles for lawful processing will be exactly the same, although there's that question mark over consent, which I think was dealt with a bit earlier on, but we'll come to. What will change, principally, is that the data subjects will suddenly have a whole load of new rights. And of course, everybody has a right, creates a corresponding obligation on the other parties, a bit like a Newtonian law of physics. If somebody gets a right, somebody has an obligation. And here, in brief summary, are the new rights. Right to be informed, so you've got to be given certain information. If you're having information processed about you, and if you are a data controller, you have to provide that information, and that would normally find its way into your privacy notices. Right of access, so the data subjects are entitled to access what information you hold, a data controller holds. Right of rectification, so if the information is incorrect, it can be corrected. The right to erasure, this is often referred to as the right to be forgotten, and there was that case with Google a couple of years ago where it became quite important. And this is now put into regulatory effect. If the information that's been held about you is incorrect, or you've withdrawn your consent, you're entitled to require, with some exceptions, that it be removed. A right to prevent further processing if there's a dispute. A right of data portability, so it's allowing for electronic transfer of information, and a right to object to data being processed about you. So they're all rights that are being granted, and they'll be effective from May. I mentioned about consent. This, to date, has been used as the get-out-of-jail card for free by data controllers. So when you get a contract, you'll find somewhere hidden in the middle of it that you're consenting to all sorts of transfers of information and processing of data about you. And by signing the general contract, you've given your consent, and that's deemed to justify most transfers of information. Going forward after May, consent will only be effective if it's freely given, specific, informed and unambiguous. So those sort of general clauses in contracts won't be effective anymore. It would have to be for specific purpose. And the purpose and the rationale behind this is that the authorities want the data controllers to be looking at the other reasons and the other principles for processing information, and not just say, let's get a consent and then we can do whatever we want. There'll be further rights for minors, although the definition which the government have put forward in the Data Protection Bill for what is a minor is anyone under the age of 14, which seems quite young, but I think accords with what lots of social media organisations and companies provide for. Subject access requests, that's going to change slightly. We already have subject access requests where the data subject asks for what information you hold about them. You have to reply. Presently, it's 42 days, and you can charge £10 for doing so. Going forward, it's going to be 1 month, although possible to extend it to 3 months, and no right to charge a fee. Otherwise, it will be the same. And accountability, that's sort of hidden away, but it's quite an important provision. What that's saying is that not only must you be compliant when we ask you about it, you must run your business on the basis that you are accountable and you are compliant with data protection regulations. Don't just rely upon the authorities to come and say, we think you've got something wrong, just amend that. As I said, a little bit on how to prepare. I always think a good starting point is to speak to the ICO and go on their website. They've got lots of good information. It's very comprehensive, it's practical, and it's free, which is always a bonus. Audit the basis of which you collect, retain, and process personal data. That's something you can do in-house. What information have you got, about whom, why are you holding it, and how long are you holding it for? Is it necessary? If you don't need to, work out policies for what information you're going to hold and when you're going to destroy it and delete it. Check your privacy notices. I mentioned about the right information that the data subjects have, and you probably need different privacy notices for different classifications data subjects. Customers, employees, suppliers, they'll all have different arrangements and you'll have different needs. If you're going to use consents, update them, make sure that they are specific. Are there any means you have for checking that if the data subject is a minor? Because if you are, and you're going to look for a consent, you're going to need a consent from a parent or guardian. Consider technical processes for data portability, if that's something your IT system's up to. Look at your marketing procedures. We'll come to it in a sec, but the old just send lots of messages out and give people the opportunity to object if they don't want to receive anymore. That unsubscribe button is not going to work going forward in most circumstances. And obtain specific consents from employees where that's appropriate. That's a particular field of mine, and that can be because the employees are more more a local person to you. They're more closer relationship. It's easier to use a consent with them, but only for the specific purposes. And if you're outsourcing any data processing, which often happens with things like payroll or marketing campaigns, you'll have to have bespoke contracts in writing with those organisations that are doing the data processing for you, and you'll be required to undertake a degree of due diligence on their processes to make sure that they are aware of the GDPR, they are compliant, and they have processes in place themselves to make sure that they're compliant and can assure security. On the direct marketing, as I mentioned, the old opt-out, unsubscribe is no longer sufficient. You either need the people who you're marketing to actually opt in. You might have noticed a lot of organisations are sending messages out with their marketing saying, we've marketed you in the past, do you still want to receive our marketing materials? And give them an opportunity to go back and say, yes, we do, and then you'll stay on their list, and if you don't answer, this assumption is you'll just disappear off their lists. Some companies have been concerned that it might reduce their marketing database, but of course the flip side of that is the marketing database they retain will be a cleaner marketing database, that people are actually interested. The alternative, if you're going to go for an opt-in, the best time to get it is when you're first engaged with the client or the individual. It's not always possible, but it's good to do that and have specific consents for what areas of marketing that they're interested in. If you can't if you're not able to do that, you haven't got their opt-in, then the only alternative is to use the legitimate interest basis, which allows you to market to clients and potential clients on the basis you have a legitimate interest in providing that information, then because they might have an interest in what you're doing. It could be something like a former client or customer, or somebody's expressed an interest in the services that you provide, as long as that doesn't override their privacy entitlements.
Can I ask a question about that? So for instance, I get added to people's lists, and as a hypnotherapist, or as a person with interest, within this, at the bottom of the thing, and I've had asked to be opted into that. Now in America, that's a no-no. You're not to do that. So is that still okay under new GDPR?
They shouldn't do so unless they can show they have a legitimate interest in contacting you about it. If there's somebody who's provided services to you in the past, they might say they have a legitimate interest. But you can always just go back and say, take me off your marketing list.
But I mean, they've just found me on the internet.
They shouldn't do that. How it's going to break down after May the 25th is difficult to say, in how it's going to break down in practice. But they shouldn't do, because if they've just dug you off of a marketing database, then they don't have a legitimate interest in sending it to you, and you haven't opted in for that purpose.
Can I just clarify what you said? For an existing marketing database,
Yeah.
is a legitimate business interest, legitimate interest that if we have your details, you must give them to us in the past because of your interest?
No, you might not have. If you've provided services to the customer client in the past, then you would have a legitimate interest in sending marketing information to them, as long as it doesn't override their rights to privacy. Now, it's difficult to be sure exactly how this is going to break down after the GDPR comes into effect. But it seems to me that the further back that contact is, the less legitimate it is. If somebody's been in touch in the last 6 months, regularly subscribes to whatever service you provide, or attends marketing events that you put on, then you're more likely to have a legitimate interest. But it is a bit of a grey area, which is why most companies are looking at the opt-in means of making sure that they got the consents. What happens if it goes wrong? There's two levels of penalties. Now these are very high, these are eye-wateringly high figures. So first tier, 10 million euros or 2% of global turnover for breach of the more reporting breaches, maintaining records, obtaining consents were relevant in addition to children's data. The more minor stuff, 10 million euros or 2% of global turnover. The more significant breaches, such as a big security breach, failure to respect data subjects' rights, would be 20 million or 4% of global turnover. Now, it is said that these fines have been highlighted and advertised quite widely as a means of ensuring that people do pay attention to GDPR, and that really they are going to be saved for the more serious of breaches and the larger companies which have the greater facilities and resources to effectively comply with GDPR. The smaller businesses are less likely to be caught out in that way. And the fines are expressed to be effective, proportionate and dissuasive. So there'll be a penal element to it. It's not compensatory. It's actually saying to you, you must do this. And if you don't, you're going to suffer because of it. But they're not looking to put people out of business. And the word I'm getting from the ICO is that they'll take a very gentle view in the first year or so of any such breaches. Okay. Right. Okay. On time?
Yes.
Excellent.
Very good. 10 out of 10. Thank you very much, Patrick.
Thank you.